when we're scouring courtroom feeds, one of the biggest things we look for is interesting arguments from the attorneys, and that's what we have here today. This particular defendant is in front of Judge Fleischer on a bond violation because he has an issue with his interlock device in his car. And they sort through that as we go through this hearing, but the defense attorney specifically questions why he even has this device as a bond condition, because he was not charged with a DUI. So that's where the interesting argument comes into play. So take a look at this video. Let us know your thoughts in the comments. Do you think this defendant should have even had an interlock in the first place? Because we're not so sure that...
Bobby Styer. It's got a bond violation. Ready?
Come up, Mr. Styer.
Not sure why. Yes, it's the bond on.
I don't know, but a bond condition is a bond condition, and when you don't live up to the bond condition, there are consequences. Just like anything in life. When you have a criminal case, you have conditions that you have to live by. And when you don't, are very serious consequences. Styer, you're on bond for fleeing a police officer. The report is that your device is in lockout, and it's been in lockout since 2024.
Yeah. You can move this year. Bond condition.
I don't remember the case, so let's do PC real quick, and then go through it.
Right. On August 17, 2024, at approximately 2 a.m., the officer of the vehicle was...
All right, folks, buckle up. This isn't your average DUI case. The twist. The defendant's being punished for a device tied to a charge he never got. Yep, an ignition interlock without a DUI conviction. So, the courtroom's about to get real interesting.
And tried to initiate a traffic stop. The vehicle had sampled a series of stops, multiple well-lit parking lots, and drove 1.46 miles from the final stop location. The defendant had red glossy eyes, continuously... I apologize. The defendant had red glossy eyes, and the vehicle was running, and the officer also observed a slight odor of alcoholic beverage from within his body. The defendant had slurred speech and repeated, "I was trying to go home, I can't work," but the defendant did not specify his place of work. The defendant denied his alcohol. The officer found a container of color XO branded container under the driver's seat, and a Taurus pistol under the passenger seat in a holster.
So what bond conditions were on there that they're alleged they're violating? You want to help me out? This is Styer. What device? She was doing the ignition interlock. I guess the magistrate put the ignition interlock.
I'm sorry, with the
I get it, but he's alleged of alcohol in the car. I don't know. Begs the question, why did they charge?
Officers are officers. We're supposed to allow them to do their job, and when their job doesn't rise to what I don't think it should be, then all of a sudden they do their job right. We want to talk to the supervisor. Officer didn't charge him, you didn't charge him. So you don't get charged with fleeing. I don't understand why advice on
Did
this.
they do field sobriety tests?
They did not.
Was there any indication that he was intoxicated?
Yeah, he has slurred speech, red glossy eyes.
They noted alcoholic. Maybe the officer didn't think it rose to the event. At any rate,
Interesting. Here's where things start heating up. The judge is about to explain why the bond violation still matters, even if the charge itself seems mismatched. Watch how carefully she balances law and fairness.
the officer didn't call it in to see every eye. And whether the statement's shoddy work or not, we don't punish anything because the officer did shoddy work.
Punish them for having bond conditions and not.
Fully understand, and that's why I wanted to address the bond condition as well as the bond. I understand that the machine's not working or lockout status, but also like, there's why were you having you do it out there?
I didn't, but I think that it's a reasonable restriction when it is, for all intents and purposes. They just didn't charge it because maybe they had an officer that was a rookie, didn't know what they were doing. I can't tell you how many reports that I have seen here that might as well have been written in Mandarin, you know? I understand.
They got a rookie or they got a shot investigation. That shouldn't be his fault. Yeah,
But it is his fault for not complying.
Absolutely.
Well, that's what happens now, Mr. Styer. So what can you possibly say that can help?
I don't, like I was saying, I don't understand why it's locked. I'm trying to talk to people about it. I told them I like just troubleshoot with the device. We'll try to figure it out on. They never gave me all that information. So yeah,
We can remedy that today, Judge.
No. I wouldn't figure it out now. I'm not going to let him go and then try to figure it out. In fact, I'd like to do it now. What do you think? Do you know why it's unlocked?
Quick legal insight. A bond condition is basically a deal. Follow these rules, and you stay free until trial. If that interlock device fails, it's a technical violation, even if it's not your fault. But here's the million-dollar question. Should he have even been required to use it?
I don't think you can think of T24 or Pascal, and so you know the
Do you mind looking in, please, for why it's unlocked out? It might take a little bit. You know, we can figure it out while we figure this out, and then maybe 5-10 minutes, we'll come back and we'll do that. And then,
We still address the officer. Part of his safety, part of his safety. They didn't make an allegation, they didn't file the charges. You still protect things outside of the fact that the machine doesn't work. He didn't make the machine, he doesn't calibrate the machine. If he doesn't work, that would be no fault of his own. We can correct that today.
let's do this. Slider. I'm going to send you now for a drug and alcohol test. Let's see what pops up.
That's good, Judge.
All right. See how he's been behaving while he's on bond.
Question is, drug test is clear. We ain't clear of any alcohol in drugs.
Let's cross that bridge when we do.
We'll do,
Do
Judge.
your drug test now, and we'll go from there. If you're clean, it'll go a long way for you. If you're dirty, cross that bridge when we get there. My only concern, Mr. Styer, is public. Nothing else matters in my life. And if you're gonna play adult games, or if you play stupid games, you win prizes or you get adult consequences, right? Where you act like a child, treat you like a child. If you do great things, then we congratulate you and reward you, right? Okay. Take it. We'll be back. So, negative goes a long way.
Boom, there it is. The defense hits the nail on the head. Why enforce a DUI restriction on a non-DUI case? This is where courtroom logic meets courtroom reality. Sometimes bond conditions are added just to be safe, but not necessarily just to be fair.